Welcome back to Verdict Files. After nearly 4 years of legal battles, this landlord-tenant case was finally set for trial. But a last-minute move by one side nearly brought everything to a halt. The judge's reaction says it all, and by the end of the hearing, the entire case takes an unexpected turn. Let's get started.
Good morning, Your Honor. This is Megan Novola on behalf of the plaintiff, P84205. Mayor, please state your name. My name is
Yes. All right. State set some time ago for a non-jury trial. The parties are proceed.
Your Honor, may I approach the bench to go off the record briefly before I begin? I have a procedural issue.
A procedural issue?
Yes. Stay on the record.
That's on.
May-
What? No, well, then I'm going to have them up here. Where I guess, what is it?
Okay, so there is a counterclaim, which is a separate full trial. There was already an order of eviction entered. I intended to force summary disposition under CA and C10. I need the opportunity to brief that issue.
Well, why am I here on the date of trial with that?
Right. So the last motion that was filed, it was back in July. I appreciate that this is a long time coming. So please, Your Honor, I'm not appreciating that for its time. However, I'm recently retained, and there's about 1,000 pages worth of evidence. This is gone to mediation. There's conflicts in the facts, even in what was submitted during mediation, and there's significant evidence indicating issues of fraud upon the court and other issues regarding insurance fraud by the defendants. And it is my professional opinion that it does substantiate claims under MSR 2.1168 and C10.
Well, the motion should have been brought before today. I mean, I don't know what particular issues you're talking about in terms of somebody committing fraud upon the court. And I'm just going to say this, if they were going to say this about the other side, if you're going to make that accusation, counsel, you better bring it. And it better be that, because if it's not, then I'm going to be exceedingly angry, because I don't like people. I do not like people accusing others of things like that without substantial proof.
Absolutely. It is a substantial issue in this case. My client's rights have been significantly violated. It's
By who?
by former tenants. This started out as a non-payment of rent case. As I mentioned, there was an eviction action. I'm sorry, there was an order of eviction. As you're aware, we're here on the bench trial for the counterclaim. I don't take a claim of fraud upon the court lightly. There is significant evidence to present that. And I don't want to disparage my client's rights by not attempting to have this dismissed under CA and C10.
Well, I get it, but there was an attorney in this before.
It's exceedingly difficult to get a hold of. That was part of why I asked to approach the bench. But
He
I understand
can count it. He was in court here Monday, so I don't know
Okay.
why he's not that difficult to get a hold of.
okay.
Coming in on the date of trial, asking for an adjournment of these proceedings is not going to happen.
Okay.
So you guys either can try to resolve this thing, or we're going to try.
Okay. Sure. Then I would request a brief recess to please speak to the defendant.
Okay. See if you guys can work it out. Court's going to stand in recess.
1480 District Court back in session, the Honorable Jake Sitters.
You may be seated. Back on the record, court does call the case Finney versus Sedona. All the parties are present, and How did the conversation go?
It wasn't entirely real. So we have back from 2021 an order for conditional dismissal. There was an eviction order entered after that time against the defendants. As it relates to today's full bench trial, it is based on a counterclaim that was filed on February 12th, 2021. However, again, it's my position that the counterclaim needs to be dismissed. There's not actual cognizable claims under the counterclaim, so that it would be right for dismissal under MCR 2.116C.
Why are they not cognizable claims?
The claims are not cognizable as defendants are now pro per in this case. This was filed by their previous counsel. There is not a cognizable claim in regard to the suspicion of a property as against my client for relief.
Why is that not cognizable?
Can you repeat the question?
Why is that not cognizable claim?
It's not a cognizable claim, Your Honor, because there is a conditional dismissal entered as it relates to the original complaint where the defendants were being sued for the non-payment of rent, where the counterclaim asserts a generalized claim without any sort of reference to a breach of habitability or constructive eviction. It's the way that it's written in this counterclaim. It's more pertinent to the affirmative defenses, given the case history here and the fact that there was an eviction order entered. At this time, this can't be a cognizable claim for the court. So
That doesn't even make any sense. If somebody says I paid $1,000 or rent was $1,000 a month, I didn't pay the $1,000, and actually I was living in conditions that I think the landlord may owe me money because I paid them or something happened to the unit. The very fact that there was an agreement to vacate the premises doesn't negate their claim for money. As it wouldn't the landlord, if the landlord had a claim for money.
absolutely, Your Honor. My point is more towards, to back up slightly, stood in court for a long time. There's a lot on the record, especially for something that started out as a non-payment of rent case. The defendants are the relatives of the plaintiff.
I'm aware.
I'm
aware of a whole lot.
There are facts in the counterclaim that are very generalized. There's just not a factual section or actual things after that. It's very generalized, but it does assert that there's a dispute as to mortgage payments. There's a dispute as to ownership interest. So this is out of the realm of a landlord-tenant non-payment rent case. And it's not a cognizable claim under the statutory law for those damages. Secondly,
You keep saying that. Give me some case law that says that.
Okay.
Up to this point, the court has spent most of the morning listening to arguments about why this case should be dismissed, delayed, or transferred elsewhere. The problem for counsel is that these issues are being raised on the day of trial after years of litigation, and the judge is becoming increasingly skeptical of the legal basis behind them. What started as a procedural discussion is now turning into a direct challenge from the bench. And as you'll see next, the judge begins pressing for clear answers while making it obvious that further delays are unlikely to be granted.
Okay, I'm going to move on to the second point briefly, and then return to that, Your Honor.
Go ahead.
Okay. Secondly, after the generalized facts in the complaint, then the defendants move on to enter under a claim of statutory conversion, common law conversion, excuse me. Well, okay.
Regarding the insurance line.
It's both. In paragraph 28, it's combined into common law conversion and conversion under MCL 600.2919A. Now, again, of course, Your Honor, we're considering what the language actually is in the counter complaint, but it's to my point that these claims are entirely convoluted. But they're asking for, as you would be entitled to under statutory conversion, 3 times the amount of actual damages plus cost of reasonable attorney's fees. If there's no summary proceedings to be had in terms of the possession of the property, and what's at issue here are ownership interests and a statutory conversion claim that exceeds $25,000, it's in the beginning, as I was arguing to you, that this would be appropriate for dismissal under MCR 2.116C7. However, even if
Jurisdictionally or under 7? Why under 7?
right, this is what I'm stating, Your Honor. In the beginning, maybe it wasn't helpful to move on to a different issue, but in the beginning, it's that there aren't recognizable claims that apply any longer, given the procedural history. Not only that, but also just the way that it's been written out here in terms of the habitability. I did need a brief moment to consult my information, but in terms of the habitability, the actual accounts that would indicate that the legal requirements have been met are not enumerated. And then secondly, it would be appropriate under NCR 4.002, not necessarily to dismiss the action, but if it's related to property ownership, which is quiet title, and if it's related to conversion for a claim of over $25,000, it's not the court's obligation to dismiss it, but it would be more proper that this be transferred to the circuit court.
And have you asked for removal?
I would request a removal, Your Honor.
I'm not removing this case. I think it was, and you coming late to the game, I think I explained to the Sidonians I don't have jurisdiction over the title.
Okay.
I also explained to them that my jurisdictional limit was $25,000. I explained that very clearly. I think I explained it actually to both sides during the couple of final settlement conferences that we had. So I don't know why it's being raised. They have elected throughout these number of years to have the case remain here. So at this point, I'm not removing it. Anything else?
I mean, I have to object to proceeding on a full hearing at this time.
On what grounds?
The numerous reasons I've stated.
You stated a lot of gobbledygook is the only way I can explain it. You haven't given me a reason. You haven't given me a reason why it shouldn't proceed today. This matter has been set for trial today. I have given a lot of leeway to both parties, I think, in terms of trying to make sure to try to resolve this case, to try to find a way to do it, sent them to mediation. They went through basically a mediation with me regarding this case on a couple of occasions. And it's come down to the date of trial. And now you come in wanting further delay. And I'm not delaying this.
It's not that at all, Your Honor. I just want to do right by my client. I was hoping I could approach the bench. I understand there's not another attorney and a party also have to be able to. But I would like to go off the record for a moment if it's acceptable to you.
Do you have any objection to that, folks? No. All right. I don't know how we're going to have this conversation. but let's do it this way. We can go off the record. Mr. Trapp, take both parties, behave yourself when you're in my hallway, take them back to the jury deliberation room. When you're seated in the deliberation room, I don't want either one of you saying anything to anybody until I get there. We clear? Ma'am, am I clear, Miss Finney? All right, take them back to my jury deliberation room. And the court will stand in recess. My understanding is the parties have had further discussions. Did anything come out of that, or are we still?
Yeah, Doctor.
Sure.
When we came back in, she asked us to step out in the hallway, and when we stepped out in the hallway, she proceeded to tell us that pretty much if we don't take the $5,200 in escrow and walk away today, that she's gonna file a lawsuit against us in a different court, that you won't be our judge, and it'll be over $25,000. So no money matters. She didn't want to talk about the money matters again, so she said escrow only. So I just leave it in your hands, Your Honor. I don't know what to do anymore.
Completely misconstruing what I said. And we shouldn't even be talking about settlement matters, but I made a valid settlement.
Counselor, if you don't want to talk about it, don't talk about it.
Yeah,
It's not going to make a difference to me.
right.
I mean, I'm just going to say this. If you go back there and talk, your client.
The hearing has now shifted far beyond technical legal arguments. Concerns about conflicting statements and litigation strategy have created visible tension in the courtroom, and the judge appears increasingly focused on the practical realities of what could happen if this case proceeds to trial. With both sides facing significant risks, the conversation is no longer just about who's right or wrong. It's becoming a question of whether continuing this fight is worth the uncertainty that lies ahead.
I'm going to let you put the testimony on, but there are certain representations that she's made to this court that you may or may not be aware of, because you got caught with one. I'm not saying caught in the sense of whatever, of a statement that she made, which is absolutely contrary to what she said before.
Right.
All right, are we ready to try this?
To be let off the case at this time?
You're looking to withdraw?
Yes. I can't reasonably represent her if I'm going to misconstrue the facts.
Well, it's not an issue of you misconstruing the facts. I'm just telling you that there have been certain representations made on the record, which I will tell you were different than what was said today. And I will tell you, counsel, I can tell by your reaction that you did not know that. So if you are going to move to withdraw, I'm going to step off, and you probably need to have a detailed conversation with your client about that. The court's going to stand in recess. Everybody can remain seated. The court does call the case of Finney versus Sedona. Parties are present. The record should reflect I've had an opportunity to talk with the parties, and parties have come to a resolution. I'll state it on the record and then ask for the concurrence that that is the agreement. Parties have agreed to a full and final settlement of all claims that could have been raised in this case or have been raised in the amount of $10,000. That will be in favor of the Sedonians. That $10,000, the amount of $5,263.17 will be released to the defendants from court escrow. The remaining amount of $4,736.83 will be paid by Ms. Finney to the Sedonians in monthly payments over a 2-year period. And counsel, that amount, what was the amount per month that you came up with?
That was $197. and 33 cents.
All right, per month for 2 years. When did she wish to begin those payments?
Next.
April? Okay. Is there a particular date in April?
30.
The April 30th? Would that be acceptable? All right. Beginning April 30th, 2025, until that is paid in full. Should the defendant miss a payment, default on the payments, an additional amount of $5,000 will be added to the $10,000 figure. The Sedones would then be entitled to a judgment in that amount, less any payments, which is inclusive of the escrow that have been made. All right. Also, I am the oral motion of counsel to withdraw once the order has been prepared. I will grant that, so that after that, the order is signed, she will have no further obligation to this case unless she undertakes it in some other way. That's the court's full understanding of the agreement of the parties. I'll start with you, Ms. Finney. Is that your understanding? Do you have any questions whatsoever regarding that? And I will ask this because of what occurred. You are satisfied with the efforts of your attorney in representing you today in this matter? All right, great. To the Sedones. Mrs. Sedone, is that your understanding of the agreement? Do you have any questions regarding that agreement? And you are satisfied with that agreement? Mr. Sedone, is that your understanding of the agreement?
Yeah.
Do you have any questions regarding the agreement? And are you satisfied with the agreement? All right, very good. I will await the order, then I will sign it. I will thank all of you for working this out today. It has been a long haul, but I think it certainly has resolved in the best interest for all of you. And I wish all of you the best.
For nearly 4 years, what started as a simple landlord-tenant dispute evolved into something far more complicated. The case between the Finney family and the Sedones had traveled through countless hearings, settlement conferences, mediation attempts, motions, and legal arguments. Along the way, emotions ran high, accusations were exchanged, and both sides became deeply entrenched in their positions. By the day of trial, the court was prepared to finally hear the evidence and bring the matter to a conclusion. But instead of opening statements and witness testimony, the morning quickly became focused on procedural disputes. A newly retained attorney attempted to delay the proceedings, arguing that the counterclaim should be dismissed or transferred to another court. The judge was not persuaded. After years of litigation, the court made it clear that further delay would not be tolerated. As tensions continued to rise, the judge expressed concern about inconsistencies in statements that had been made throughout the case. Those concerns led to private discussions between attorney and client, forcing everyone involved to take a hard look at the risks of moving forward. At that moment, both sides faced a choice. They could continue fighting, spend more time and money, and leave their future in the hands of the court. Or they could finally reach an agreement and bring the dispute to an end. Ultimately, they chose settlement. Under the agreement placed on a record, the Sedones would receive a total of $10,000. Part of that amount would be released from escrow immediately, while the remainder would be paid over the next 2 years. The settlement resolved not only the claims that had been filed, but any claims that could have been brought arising from the dispute. After years of conflict, uncertainty, and litigation, the parties finally reached a resolution that allowed everyone to move forward. In the closing moment of the hearing, the judge thanked both sides for working through their differences and recognized the effort it took to bring such a long-running case to a conclusion. Cases like this serve as a reminder that lawsuits often take on a life of their own. What begins as a disagreement can grow into years of stress, expense, and frustration. Sometimes the most important victory isn't winning at trial. It's finding a way to end the conflict and move on. For these parties, that day finally arrived, and after years of litigation, the case was over. In the end, a case that seemed destined for trial took a very different path. After years of litigation, procedural disputes, settlement conferences, and courtroom arguments, both sides ultimately decided that reaching an agreement was better than continuing the fight. The settlement brought an end to nearly 4 years of conflict and resolved not only the claims that had already been filed, but any future claims arising from the dispute as well. While neither side walked away with everything they wanted, both parties finally gained something that had been missing for years: closure. What do you think? Should this case have gone all the way to trial? Or did the parties make the right decision by settling when they did? Let us know in the comments below. If you enjoyed this video, hit the like button. If you didn't, hit dislike. Either way, share your thoughts in the comments, and don't forget to subscribe to Verdict Files for more courtroom moments, legal disputes, and unforgettable hearings.